Hello, everybody. Now your silence down already. Let's come on and have some block talk. We will have some wine later on again. It is my pleasure to welcome you to Block&Wine. We have today a lot of block and the law. A talk with Giti and Clemens about DAO legal challenges, and then, of course, the causa prima, the causa of the hour, TFR and MiCA today. So my pleasure to welcome you all here. Without any further ado, I would like you to shoot out, give them all an applause to Giti and Clemens. They will start with the first talk of DAO and the legal challenges. Welcome.
Thank you, thank you. Hello, everybody. Ist hier irgendjemand, der vielleicht kein Englisch sprechen kann? Okay, good. So, we will talk in English. I have good news and bad news for you. The bad news is, as you can hear, I'm not a native speaker. To be honest, my English is very poor. But I hope you will understand everything. And the good news is I will only ask the questions. So the expert sits next to me. Hello, Giti.
Hi. Working? Hi, Clemens.
Habe ich auch einen Schummelzettel bei mir.
That's cheating.
So we will talk about DAOs, decentralized autonomous organizations. You may know my voice from a podcast called krypto.logisch, and we have a setup where I ask the stupid questions and the experts answer me the very intelligent things. And you are the expert today. So tell me, Giti, what is a DAO?
Let's jump right in, or?
Of course. I forget. I didn't introduce you. I'm so sorry. So I'm still nervous in front of people. I'm very sorry. So Giti, you're a legal expert focused on Web3. You worked for the university in Vienna and also for international law firms. And we will demystify the DAOs today. I hope so. Right? So.
I hope so too.
Now is the question, right? Or do you want to say anything else?
No, it's fine. It's fine. All good. Yeah, first of all, maybe just a quick note on why we chose the subject today, or how we came to the DAOs at all.
If you want to, of course, tell me. Why did you choose the subject?
I mean, DAOs are in everyone's mouth these days. I think everyone have read so many things. It's so blown up in different bubbles, and our approach today was to demystify it. And I myself, background-wise, was also always in the sort of intersection of tech and law, and moved towards this field and got more and more exposure in Web3 topics in general. But with DAOs, it was something completely different. I hadn't had any touching points so far, because I don't know any DAOs in Austria so far. But I was talking to some members of the Wharton blockchain and digital assets working group, and they just recently published a paper with the WEF on DAOs, and just that's when I got just super intrigued and dig deeper, and through that got to know some other major protocols are just working on DAOs. And if you just look at them, you notice that the DAOs information right now, wherever they are, they just have the same challenges, the same issues. So it would just make sense to sort of zoom out and not see it through the lens of just one jurisdiction. In my case, it would be the Austrian law perspective, but to rather get an overall approach. and at the same time, of course, get to the basics and just demystify and see what the DAO exactly is. So, as you already mentioned, decentralized autonomous organization. Of course, we all know the buzzword. It's a general term at the end for a group of people who use blockchain or related technologies to organize themselves. Just that simple.
So you said it's in everybody's mouth. I never heard of DAOs before until last week. So I am the noob, as you can hear, and tell me more about DAO. If there is no management body, it sounds like chaos. How is it structured, an organization form like DAO? Decentralized and autonomous.
Yeah, decentralized, that's I think the buzzword here. So when we talk about DAOs, we have to distinguish between the several aspects of it. So first of all, a DAO itself is just a governing mechanism, and the governing mechanism that happen to be smart contract based and self-executing. But the DAO itself can be used to organize a group from within, to structure their decision-making processes, the allocation of resources, the pooling of money. And that's where we get to the structure. So I think in order to really grasp the structure, it's good to make a comparison to a corporate structure everyone knows, or with what we've been working so far. So as an example, let's just take a limited liability company. In there we have the company as such, the legal entity. Then we have the shareholder holding share in the company. We have some sort of organ representing the company outwardly, let's say managing directors. The roles are pretty fixed. Everyone knows who owns what. The actual funds, resources, and so on are owned by the company itself, not by the shareholders. The shareholders have their shares in the company. We have a strict line in the liability. That's why it's a limited liability company. And that's the exact opposite in DAOs. We don't have the company as a legal entity as such. There's no hierarchy. We don't have an organ to represent the DAO per se, no managing board whatsoever. What we have is only the level of the shareholders, and in that term, it would be the participants or the contributors. Everyone uses a different term, but we'll stick to participants. And these participants will have a share of the DAO. And that's exactly what's super interesting about the DAOs, this completely new definition of ownership, because so far it was clear that the legal entity has ownership over its goods and funds and whatsoever. But here we don't have it, so the ownership is distributed between these participants, and that's something we hadn't had so far in the structures we've known amongst jurisdictions. We have it now in some, but I think we'll get to there. Anyway.
So are there different types of DAOs? And if yes, what types of DAOs are there?
Yeah, by now there's so many. I just read a number recently by the analytics firm DeepDAO that this year there's supposed to be over 4,000 different DAOs. But mainly you can differentiate between the purposes. So it's not a fixed thing. You can make a DAO for basically any purpose. The most common one is, of course, the investment DAO. where you just gather together, you pool money and make decisions collectively to invest in whatever you want, basically. But you also have social DAOs, which is more sort of a group chat thing, not so complicated. You have media DAOs by now, all sorts of it. I read of you may have read about the the Constitution DAO from last year in the US.
Of course, I read about it.
Or just recently there was the Ukraine DAO where they just pooled money as an aid and tried to help. But there are no rules, there are no restrictions.
And if I want to participate in a DAO, what do I have to do?
Yeah, so usually if you want to participate in a DAO, the way it usually works is that you would be some sort of governance token holder, and with the token you would be allocated the rights and obligations that come with it. So that's basically your ticket in. Yeah. There are probably other ways by now, but that's the most common one.
So, and now the question of today, what are the main legal challenges of DAOs?
There are a couple. There are many legal challenges. I mentioned before the structure of a DAO is something completely new. So we don't have this legal person, we don't have the legal entity. Some say that you, in order to participate in everyday transaction, do need some sort of legal person, so that you have some sort of legal wrapper. It can be an LLC, it can be a foundation, a trust, association, whatsoever. Because when you don't, that's one opinion, when you don't have any legal form, the law still applies. There's no vacuum just because you don't give it a name. So the risk here is that it will be considered a general partnership. And that's bad for the participants because there you have no limitation of liability. So if the DAO as such has any debt, any obligations, liabilities, it would come directly to your private funds. That's something you don't want to have.
I would have to pay personally from my own bank account.
There's the risk that it would be considered as such and then you would have to. But that's only the one side. So there is no legal wrapper as such. The other one is that many jurisdictions haven't yet recognized the DAO as such. We have 2-3 states in the US so far. It's Wyoming last year with the Wyoming Bill 38, I think in the summer, where they for the first time recognized the DAO as an entity. I think Tennessee just followed up, but that's about it.
In Europe?
No specific one. There are, of course, I mean, you do see trends. You need some sort of legal wrapper in practice. You do see trends right now in Europe. Everything is sort of looking towards Switzerland. The Swiss Foundation is being used, the Swiss Association, just because they don't have shareholders as such. And that's exactly the spirit, sort of, or the point of a DAO, that you don't have shareholders that are recognizable. So you have this anonymity element in it. And generally, I think the regulatory framework in Switzerland is just more crypto-friendly. So I think it could have been done anywhere because there are no legal frameworks so far, so you could just do it anywhere. But there you already have a practice, and you can talk to the authorities to some extent, and it's just practically, I think, easier there in Europe. In the US, they have, for example, the trusts, which they use more often, which we don't use in Europe. But still, you just have to try and error at the moment.
So the main problem is that there is no legal wrapper for this whole thing.
Yeah. If you don't have a legal wrapper, you're not as such participating in everyday transactions.
So are there any possible solutions at the moment, or in discussions, or already in actual use?
Yeah, sorry, one point to the problems. What's often being asked about DAOs is also the question of is it even scalable? Like there's no...
Is it?
There's no possibility how to scale up a DAO. That's a bit difficult because there's a theory and a practice. So in theory, the theory is that in contrast to a company which is led by CEO, driven forward, scale up, whatsoever, we have a scale out here. So everyone's on the same level, it's sort of peer-to-peer, no hierarchies. And you make sub-DAOs, teams in which you work, and you rather spread out instead of up. But then again, if you look at the practice or the reality, I'm not sure if this bottom-up approach is that common. Because if you have a DAO where just a couple of, mostly the issuers, have most of the tokens, so it's again a similar structure, but just in a different frame. So it's again a top-down. But that's also one of the issues there is. In terms of solutions, that's the main question at the moment. I've talked to super amazing major protocols who are just about to try them out. There's no one way to go. Uniswap, for example, I'm not sure if they have a legal wrapper at all. I don't think so, and they're one of the biggest DAOs at the moment. So they'll just try and see what happens.
So what do you think, is there a future for DAOs?
Oh, definitely, definitely.
So we have to find a legal wrapper for it.
Yeah, sure. You don't have to. I mean, it depends. You don't actually have to have a legal wrapper if you're not intending to have the operations where you would need one. Let's say you have a social DAO with no implications in terms of change of money. Money is not changing hands. There's no tax implication, which otherwise be a major issue. I don't see a reason to have a legal wrapper around at the first place. And the other thing that's also being done at the moment is that you just extract the part that needs a legal wrapper into an American Inc. or LLC, whatsoever, and the rest you have to DAO until you have a better idea. But you can also just sort of split it. That's also an option.
So do you have something else to tell about DAOs to the audience? Or are we at the end of our discussion?
If you don't have any more questions for me, I think...
No, I don't. I think it's very complicated but very interesting topic, and looking forward where the DAOs go. So are there any questions in the audience about DAOs? Yes. Haben wir ein eigenes Mikrofon für Publikum? Hier vorne.
Thanks. Oliver Völkel. So just a comment and a question. My comment is, I think what's really important to always consider is that the law aims at regulating people, what people are doing. And also when you look at what a DAO is, at the end it's a bunch of people who come together and use smart contracts, as you put it, to regulate their decision-finding processes, for example. And I just wanted to ask you, since you also mentioned you would look at it from the Austrian law perspective, considering that it's really your people who are dealing with one another, and looking into the various types of legal entities that you have at your disposal, and also considering what you said, smart contracts are just used to structure decision-making processes, and again, you need some people who interact with the real world. It can't be the DAO alone. Wouldn't you think that you could simply use, for example, a limited liability company and a smart contract that simply is a means of the people to find their or to find decisions?
Yeah, definitely, you can do that, and I think there are already examples for that, especially when it comes to investment DAOs. Investment DAOs are nothing else than investment groups sort of things. So when you're eager to invest with other people, you also have an interest to know who the others are. So in an LLC, you wouldn't have the anonymity thing. Sure, you can do that, but I would say it's not entirely in the sense of a DAO which wants to be anonymous. But for investment DAOs, definitely, I don't think there's a reason why it shouldn't work. And also, if you have difficulties with the interaction with others, you can also appoint a person. I mean, you just have a normal, within a DAO, I mean, you have a normal decision-making process, hopefully set in place beforehand. The participant decides who's going to be sort of the representative. Easily done, from my perspective.
Any more questions?
Yeah, I got one. Maybe that's an open question, because we immediately touched it, and the question rather is whether the future of work, which is something which all of us a little bit drives us, also how we work in the future and how we collaborate in the future. What could a DAO be an answer to that question, how we organize work together, or is it work then, or is it just a bunch of freelancers or semi-autonomous people interacted in a smart contract with each other? So could that be an answer? Is there an answer? Is there an question to that future of work and DAOs?
Yeah, I mean, I do see parallels between how DAOs operate at the moment and how the new work sort of thing or the future of work is leading. I think also in practice, it's more like a group of people you work with. I don't think anyone works with 1,000 people on a daily basis. So you sort of have this one circle of 10, 20 people you actually work with. And that's actually exactly the same how a DAO operates. So you have a huge structure, probably with hundreds or maybe thousands of participants, but then you again have either sub-DAOs or you have teams within where you work. I think the incentive would be a different one. Since you're invested in a different way, you have just a different drive and purpose when it comes to the product itself. I mean, there are also product DAOs where you just gather together, work on a product, give it away or whatsoever. So if you would think that any person participating in the DAO would have ownership of a part of the product, I think that's an incentive in itself. It's like ESOPs, VSOPs, whatsoever. equity in the company. I think it's both going to the similar direction. Does that answer your question?
Yeah, absolutely. Cool, thanks.
And Georg, who is also one of the hosts of krypto.logisch podcast, I think that would be a great topic for one of the next episodes.
Absolutely. And to some extent at our podcast, we try to live a DAO as well. So maybe we can reflect in a podcast on our experience on that as well. So could be a good idea. So thank you too.
Wait, I think there was one more question. You? Okay. And behind?
So maybe a new question, but a DAO solves a problem. I'm not really understanding what they are solving, but changes happen all the time in organization also. How do you bug fix a DAO? How do you change it to adapt to a new legal situation, or, well, all kinds of things that are happening if you discover you have to change the DAO in itself?
You mean it's not flexible enough? Yeah, I would say yes. Of course, at the beginning, you have to, as a group, agree on some basic governance rules, how you want your group to operate. You put them, you code them, you have the smart contract. It will self-execute. And then for any other decision that comes along, you already have the mechanism set in place. So you already know if the decision has to be made upon whether someone's gonna join the DAO or not. You need a quorum of, let's see, half or 3/3. That's already set in place. You can't put everyday questions into one smart contract, I think. So in that sense, I think it's pretty flexible. The same how a LLC works. You have the declaration of the LLC, and then any other decision will be made in the General Assembly.
All right, one last question.
One question, yes. The question has two parts. First, aren't there laws out there which come close to a DAO law? First part, so like Austrian Stiftungsrecht, foundations, and American trusts. And second part is, what would we need for, why a specific law for DAOs? And what would that law look like?
I didn't understand the second question, like what the ideal legal framework would look like.
Why would we need a specific regulation on DAOs, and how would that look like? What's the specific compared to PLCs and other limited liability companies?
Yeah. Okay, I'll just start, if it's okay. No, so far we don't have an exact jurisdiction for the purpose of a DAO as a legal entity, with 2 to 3 exemptions, which are in the US. Wyoming, Tennessee, and Vermont is working on one. They will follow up soon. In terms of what would be similar, what you could use, definitely a Stiftung, foundation. Yeah. Otherwise, I wouldn't say you have to be restricted to the Austrian jurisdictions. As mentioned before, the trend is really to go to Switzerland because it's way more flexible, their understanding of an association and a foundation. It's quicker to set up, so why not just, be flexible and do it there. Under Austrian law, I think anything that doesn't have exact shareholders, unless it's an investment DAO, would be a good approach, because you want them to be anonymous in some sort, and you have it in foundations. The second question was, what would the ideal law look like? That's a good question. Ooh. That's so difficult because we're so used to the corporate structures and frameworks we've been working with the last 100 years. And also the structures that are, or the US that has already the DAO LLCs, it doesn't answer the core questions, doesn't answer anything. It does answer, but doesn't answer everything. So there's still questions open. So I'm really not sure how the ideal legal framework should look like, because it's such a different approach to ownership, which we have for hundreds of thousands of years. So it has to be a super, super creative set of laws, I think. I think there was a follow-up.
Hi. So first of all, isn't the whole Web 3.0 and everything that has been happening with respect to digital asset an intent to innovation and a drive to innovation, which is what we see in the form of DAOs, which is what we see in DeFi, which is what we see in the new wave of financial system, if we can call it that, the digital assets, crypto sphere. Second is a comment in the whole movement of basically traditional legal structuring moving from identifying shareholders to identifying ultimate beneficial owners, which is pretty much what the DAO kind of replicate in their own decentralized way. So the question that comes in, isn't DAO a new form of innovation in terms of legal corporate structures? And isn't this basically a question of how do we innovate when we're looking at corporate legal structures?
If I understood your question correctly, I think it's important to make the distinction between the DAO as itself. Yet again, I'm sorry, I have to emphasize that, and the legal wrapper around it. A DAO can operate in any sort of legal entity. We just discussed the types that come into questions. Some of them are more in the sense of how a DAO should work, some less, but it does its job, as DAO itself is just an internal governing mechanism. So not sure why, or what was exactly your...
The question is, and what I see as a silver lining, everybody seems to be focused or asking, what is the legal representation? So how can you basically register a DAO? Which is, you can register as an LLC, you can register a Stiftung, as a trust, etc. But is that really the representation? And that's why it's a follow-up to the previous question. Isn't it a need, actually, for innovation also in the legal sector, where you need to recognize what's happening around the globe and just put in place new systems, new regulation, new legal provisions?
Now I get the connection to the previous question. So that's again a question of how the ideal legal framework should look like. Definitely there's place for innovation. And whatever country is doing the work will be super happy with future DAOs registering there. Definitely, there's room for innovation. That's clear, yeah. Totally.
I'll just ask one more last question, but it'll be an easy one about politics. Right? Easy questions about politics, right? First of all, I'm Josh from Crypto Mondays, coming from New York City. I'm the global liaison for Crypto Mondays. And Crypto Mondays is the world's oldest and largest meetups for crypto, blockchain, DeFi, NFTs. And I'm very happy to announce that with the help of people like Block&Wine and DLT Austria, that we're going to be setting up Crypto Mondays in Vienna, which will be the 80th city around the world that we have Crypto Mondays in. So I'm hoping that the blockchain community around here is excited about that. And Crypto Mondays is a DAO itself. And last week at NFT NYC, was anybody at NFT NYC? I'm one of the organizers of that event. All right, a few people. At NFT NYC, we had Andrew Yang on Crypto Mondays as our special guest, just like you're a special guest tonight. And he was a presidential candidate in the last election, and he was talking about the use of DAOs for their political parties. And they have his political party, which is not the Democrats or the Republicans, but what's called the Forward Party, which is an independent party. They have now made a DAO. He actually announced it on Crypto Mondays for their political party. And I'm just wondering, you didn't really mention that too much, but someone questioned the validity or utility of DAOs. What do you see as the utility or the value of DAOs for politics and democracy in general? I know that's an easy question.
I had the same question yesterday when we talked before. Yes, I had the absolute same question.
Sweet, man.
We were discussing this yesterday. Where do I see the use? I would say for the parties as such. In the US, if you have the Republicans, Democrats, just for the internal sort of decision-making processes, I think there would be a good use for that. Otherwise, in a broader sense, what does it mean for the democracy? I don't think you can hold whole elections with some sort of DAO involved. I'm not sure how that would work. But definitely, the DAOs are a tool to democratize, so it does have a democratic sort of touch to it as you come down from the top-down structures. But yeah, I think within the political parties it would be a good use, but not cross.
Okay, thank you, Giti, for all your answers. I think there are still many open questions out there about the legal challenges about DAO, because it is such a big topic, innovative topic. But I hope we demystify a little bit of it today, and maybe we see each other again at krypto.logisch.
Would love to.
I hope so. Then we can talk in German. Then I also understand more. So thank you for your attention. We're coming to the next point of the day. Oh. Thank you.
Thank you.
So have a nice evening. Bye-bye.
Thank you, Clemens. Thank you, Giti. Now we get into the second part of the night's evening. It's, the matter of the hour. It's MiCA and TFR. What is MiCA and TFR? It's the markets in crypto assets regulation and the transfer of funds regulation. I won't do any introduction because that it's up to Oliver Völkel. He is up on stage. Give us a little introduction on what's about MiCA. I don't necessarily need to introduce Oliver, just two sentences which are important. You're the pioneer when it comes to blockchain at the law in Austria. You are the host, so to speak, of the first security token offering in Austria. That's correct, right? And further other improvements. So it's very gorgeous that you're here and that you talk about this fundamental matter, which crypto and the law will last for the next decades, I'd guess. So thanks, Oliver, to bring us the matter of MiCA a little bit closer, and then we'll have some talks about that. Oliver, the floor is yours.
Thanks, Georg, for the kind introduction. a few words about myself. I'm Oliver Völkel. I'm an attorney here in Austria, in the beautiful center of Vienna, not far away from here. Yeah, my partner in this law firm, Arthur Stadler, who I founded this firm with, and we have, put a large emphasis on blockchain-related matters from the very beginning, which was 2016, which is ages ago, it seems. Yeah, a couple of things have changed since then. So, for example, the fifth anti-money laundering directive came into place, where we first got a definition of virtual currencies, and now it seems as though we will finally get a full regulatory framework of crypto assets. And that's actually what I want to speak about today. I was asked to keep it very brief, so we have two options really. Either I stick with my first slide, which doesn't really... okay, this is actually the last slide, so I have to go backwards to go to the first slide. I mean, it's not that many, but still. Yeah, markets and crypto assets regulation, that's what I want to speak about a little bit. And also, perhaps on a side note, I really didn't realize up until now that this whole talk was to be given in English. So for the German-speaking audience here, you will perhaps have something, or you will be able to read this, the others won't. So perhaps I will stick just to the first page. Crypto assets, asset reference tokens, e-money tokens, are new concepts which are now only being introduced by the markets and crypto assets regulation. And perhaps before we dive right in, I'd like to give a short summary of where we're currently standing. So we had a first proposal in 2020. We had numerous further proposals and discussion rounds and amendments. Frankly, or to give you a bit of a background, how I have the knowledge that I have now. Unfortunately, I'm not, I don't have access immediately to what's going on the political level. It's rather that I work with the texts and see the protocols of what's been discussed. And we already have clients, namely actually from the banking space, who are looking very, very carefully what's being drafted in Brussels, because they see, and perhaps this is a main takeaway, banks and financial institutions will benefit massively from MiCA. About as much as securities firms have a benefit from the pilot regime. It's really a legislation for them, and really MiCA is legislation for financial institutions, if you will. Okay, so what are crypto assets? Crypto assets will be defined by MiCA. Oh yeah, and to wrap up the process where we're currently standing. So on 30th of June, the political agreement was reached. And as far as I understand, there's a couple of technical talks now where specifics are being discussed, but those topics that I would like to discuss with you today, I think they are pretty much settled. And what are those topics? Mainly the definitions. So we have a definition of what a crypto asset means. We have a definition of what a crypto asset is. And if you look here, it's a digital representation. Okay, I need to make sure that I speak in the right direction. Perhaps if I walk the other way. Crypto asset is a digital representation of value or right, which may be transferred and stored electronically using distributed ledger technology or similar. So we have a digital representation of a value of a right. It's basically designed to be a catch-all phrase. Most of the tokens, and we'll come to NFTs later, will fall under this definition as long as they represent a value or a right in some sense. So your classical coin, Bitcoin, would be a crypto asset in this sense, or a token that purports to be used in connection with some with a DAO, for example, or a smart contract that will also fall under this. What's important, the regular crypto asset is going to be regulated not that burdensomely, if you want to put it that way. So you'll have notification obligations as an issuer of crypto assets. you'll have to draw up a white paper, and you'll have to notify the regulator, in Austria, the FMA, but you'll not have to wait for an approval, such as is the case currently, for example, under the prospectus regulation. If you want to offer securities, you need an approval from the regulator. So the idea is to have quick turnarounds, and it shouldn't take longer than 3 months. Yeah, crypto asset service providers are, I'm pretty sure you all know what they are and what they do. I think I can skip this slide. But what I'd like to discuss with you a little bit in more detail, because I think it's really a fascinating thing, are the so-called asset reference tokens. As you can see, an asset reference token is also going to be a crypto asset, so you have to apply all the legal contours of what a crypto asset is, and have to import it into this definition. It needs to be a crypto asset that is not electronic money, that is not an electronic money token. We'll speak about that soon. And that purports, and that's an important word, to maintain a stable value by referencing the value of more assets, of one or more assets. Also, the definition might change slightly, but in the general gist, that's what it's going to look like. So why is this definition important, or what's it all about? So first, your token, I would now just say the instrument, your token purports to maintain a stable value in relation to a referenced asset. The first thing that was unclear in the process of bringing about this definition was whether or not this would allow you to, for example, issue a token which purports to maintain a stable value just in relation to, let's say, a Tesla share, to one asset, a share in this example, or whether or not you have to have a whole collection of different assets. This has been clarified now. You can really use asset reference tokens to reference just a single asset. And if you think about it for a second, really the question is, what's the difference between such an asset reference token and a financial instrument, a total return swap, for example? You could imagine a business model where an issuer sells a token that purports to maintain a stable value to a Tesla share, for example. And the idea is basically, I, as the issuer, give you the token, you as the purchaser give me some money, precisely the value of the Tesla share at the present day. And some point in the future, I would return this token to you, and you, the issuer, return to me the then present value of the Tesla share. And basically what we have done is sort of reinvented the future, or reinvented the total return swap. And this is really a crucial, and why is this important? If you want to offer financial instruments, you're falling under MiFID or under the prospectus regime, which is a rather strict and burdensome regime to offer financial instruments. However, if you are an asset reference token, you do not have to comply with any of those obligations. And that's the funny part, you can still, as an issuer, rely on the European passport mechanism, set up a white paper for for asset reference token. This particular white paper for asset reference tokens has to be approved by the regulator, by the way. But nonetheless, you got your white paper, you can notify it into into other member states of the European Union, and then sell your asset reference tokens. And that's much easier than selling a financial instrument, such as a total return swap or as a future or whatever, to customers. Why? Because for selling financial instruments, you need financial intermediaries, security companies, and you need to basically comply with the local regime, which is slightly different in all of the member states. And you can circumvent this completely. You structure your instrument as an asset reference token, and circumvent the requirement to have local financial intermediaries. By local, I mean in the respective jurisdictions. And so really a key question, and why do I bring this up? Well, this is an aspect, or this is something that financial institutions look at very closely, because it opens up a whole new market for them. As I said, they're in a very favorable position when you look at the MiCA texts. They are allowed to actually conduct all of the business without having to obtain licenses for the asset reference token, for example. They just have to notify the regulator. And so the question, what's the difference between an asset reference token and a financial instrument, is really, really crucial. And in fact, we noticed that there are ways to construct an asset reference token, which is not a financial instrument. And this is just something that I wanted to stress and point out. And that's why I say MiCA is really a law made for financial institutions, because this is their business model, and they will simply use the technology to enforce this. And then what's also really interesting is this word purport. When I first stumbled across this word purport, I was a bit perplexed, because what do you mean by the asset it's sufficient for the asset reference token to just purport to have a stable value. I now do understand what the idea behind all of this is. As soon as you offer a token and you claim it maintains a stable value, whether or not it really does, there may be no legal mechanism put in place why your asset reference token should even maintain its value. There may not be an obligation to exchange the token for the underlying assets, for example. You may not even grant this right, but still, since you claim it, since this token purports it, it should be regarded as an asset reference token, and it must comply with the obligations. One of which, for example, is that you need to maintain a reserve, and it needs to be interchangeable for the underlying, or for the reference asset in this case. Yeah, e-money tokens are basically asset reference tokens, with the exception that they only reference an official currency of a member state. Other than that, they're not very interesting in my estimation. I think this is also not that important, but perhaps let's stick with NFTs for a second. And here I have to point out that we do not have the final text yet, only what's been discussed and information from secondary sources, in my case, what the current status is. But it seems as though the technology NFT should not be conflated with what is usually sold when it's called NFT, when something is called an NFT. And for all intents and purposes, and most likely what the regulation is going to be, or what the regulation is going to look like, is the following. If your NFT represents an item or a number of items which are not interchangeable with one another because they have a market value independent of one another. So think of 10 pictures of, I don't know, I don't want to say apes, but 10 pictures of apes, and they are traded at different market values. Then this would not fall under the regulation. If you are using the technology NFT it's slightly differently. For example, think of banknotes. Each banknote actually has a unique identification number. But nonetheless, the function of the banknotes is to be interchangeable. And if you're using the technology of NFTs just to try and circumvent the regulation, this is not going to work. So if you're using NFTs, but you still have an instrument that's fungible, basically, you will fall under the MiCA rules. So that's what I wanted to share at the moment, give you some insights, what we've looked into in our legal practice, and we did a lot more, and I'm happy to share my thoughts on any questions that you may have.
That's great, Oliver. We will have then the chance with Martin as a respondent then later on, or just right away. That's cool. Yeah, go ahead. Come on stage. Let's welcome Martin Erhold from Bitpanda. I think he's one of the most profound experts in this area to respond on that, what Oliver just said. So welcome on stage, and please take a seat, both on stage.
I don't know, maybe, thank you, Georg, thank you, Oliver, especially. Hi, everybody. I'd also invite the other two panelists, maybe, so we can have more of an open discussion, maybe. Would that be okay?
Let's go ahead.
Yeah, thank you. Okay, hi everybody. As Georg said, my name is Martin. I work for Bitpanda, so one of the crypto asset exchanges that Oliver mentioned, and it's really great to be here today to speak about MiCA. It's been a long way coming, 2 years of negotiations, and now we've got 20 minutes to cover it all. But Oliver did a great job at stressing, I think, some of the most contentious points that we see in the file. But I'd like to start by saying that from a general perspective, and if you look at the bigger picture, I mean, as adopters, we definitely have a lot of things that we can criticize about it, and it's unfinished at the end of the day, maybe. But MiCA in itself is a huge game changer. This is really a hallmark legislation for Europe. And not only for Europe, but I think globally, because we're the biggest, one of the big economic blocks that have achieved something that was considered probably, at least very difficult a couple of years back. Will this, address all the concerns that we have? No, obviously not. The crypto space is developing with lightning speed, as you can see. But I think it was very wise also from the legislator to leave out a couple of aspects such as DeFi, and NFTs maybe too, nobody knows if they're really left out. As Oliver said, this is going to be interesting to see. But a couple of things should be looked at more carefully, and then we need to take really good policy decisions going forward. But what we have with MiCA, and that brings me back to what Oliver said, is a very holistic approach. It's great to see that. We're going to have a licensing regime with single passporting, which is a massive improvement to the current system that we have with 27 different registration regimes in in Europe. We have a very interesting, I would say, taxonomy when it comes to crypto assets. Let's see how that plays out, especially the asset reference tokens that Oliver mentioned. We really don't know what this is going to bring. The distinction between financial instruments and asset reference tokens is absolutely unclear, as Oliver said. We have two very different approaches in terms of how we approach arts and how we approach financial instruments. But at the end of the day, for arts, you need to obtain a license, and then pretty much you're free to do whatever you want in Europe. Whereas if I issue a derivative at the moment under MiFID, I don't have any licensing requirements, but I obviously do have prospectus requirements and marketing requirements across Europe. And those prospectus and marketing requirements, at least if they're not pursuant to the prospectus regulation, can be very different in the 27 member states. And because we have minimum harmonization in the financial investment instruments, financial instruments framework, and maximum harmonization on MiCA, we really don't see, or we don't see that yet, how that is, how that's going to work out. But it seems as though ESMA is going to come up with a Howey test of some sorts for Europe. That's definitely going to be very interesting. Also, maybe something that the intention is clear when they state that asset reference tokens are stable coins, e-money tokens are stable coins. But, and as Oliver said, if you prefer to maintain a stable value, stability is relative in itself, as we also see with currency at the moment. With the high inflation. So it's a really interesting approach to try to regulate something that I think the legislator wanted to regulate because it seems as though it's been used as a means of payment. But coming up with a definition such as that for asset reference tokens, I would say that at the end of the day, I don't know whether any of those instruments will ever be used as a means of payment. But that remains to be seen. But in a nutshell, I would say we have a lot to discuss, and the work has only started. Why? Because there's so many elements in MiCA that will need to be clarified in level 2 legislation. So even more important, or just as important as the framework we have at our hand at the moment. But it's really exciting. It's great to be in Europe at the moment in the crypto space. Well, the market sentiment is very, peculiar at the moment. But overall, I would say this is just what we have to deal with at the moment. But we're definitely building here in Europe, and we're trailblazing as well. So I'm sure that all the other jurisdictions, including the United States and others, will be looking closely at what we're doing here in Brussels and across Europe. And I think we can set the benchmark, albeit all the smaller issues that we face, technical issues and potential over-regulation in some aspects. But then again, we really welcome MiCA. Why? Because this is legal certainty. This is what we've been looking for, and what legal certainty will bring is institutional adoption, further retail adoption, because we have consumer protection. And at the end of the day, we will have a very mature market with mature market participants, professionalization across the board, which is great. Potential downside to all of that is we have such a holistic framework, and to a certain extent also very, very strict framework, that this will widen the moat that we see around bigger players in the sector probably. It will be hard for smaller players to come up with these compliance setups that are required for MiCA. I think that is a given. So what we do expect is some kind of consolidation in the market. And as Oliver also mentioned, banks and other traditional financial players are really looking into this and are probably ready to hit the ground running as soon as MiCA is in force and effect. So that will also be very interesting to see how that plays out. Thank you.
You gave me the keywords, 2 keywords. First, here in Brussels, and second, to give us the bigger picture. I would like now to hand over to Max Bernt. Actually was heavily involved in the drafting process of the TFR, and this is the bigger picture. We're not only talking about MiCA, we're also talking about the transfer of funds regulations, all that issue we had with our unhosted wallets just in our bucket, right? So Max, it is my pleasure that you please represent to us what's all about the TFR and unhosted wallets. And it's also very great that we'll have one respondent here as well, who will be then briefly respond to that. Martin Hanzl, if you look for a smart contract expert here in Austria, here's the guy, talk to him. He will solve all smart contract issues reflecting to the law. So pleasure to have you here. And Max, I'll hand over to you. You've got the presenter from Oliver.
Oh, thank you very much. So let me introduce myself just quickly as an add-on to what already Georg said. My name's Max, I'm Chief Legal Officer at Blockpit. And like Georg already mentioned, we were also heavily involved into the political process when TFR and MiCA was being negotiated. And I can just fully agree with what Oliver as well as my pre-speaker said just right now. You mentioned everything basically that we wanted to say as well. So yeah, let's follow up with TFR. What's a TFR? TFR is the Transfer of Funds Regulation. It's part of the European AML package, which includes 4 instruments: the AMLR, the EMLA, the TFR, and the, what else? The AMLD 6. So TFR was in the headlines of a lot of, you read a lot about it in the past months, namely because there were a lot of questions that were discussed in the process of negotiating TFR. What does TFR even mean? So let me start, but I aim, and maybe I get downstairs, it's easier. The aim and the scope of TFR. So the TFR is the Transfer of Funds Regulation. The main aim of TFR is to implement the travel rule within the European Union's crypto economy. What is the travel rule? The travel rule is a recommendation by the Financial Action Task Force on the level of the OECD, which foresees that financial institutions are required to pass on certain information about users, about their customers, especially the beneficiary and the originator of a certain transaction, to other financial institutions. And what is done right now via TFR is that CASPs, crypto asset service provider, in the meaning of MiCA, are now obliged to pass on this information to other CASPs as well. The question is, what's now in TFR and what isn't? There was a lot of talks going on about TFR banning unhosted wallets. There was a lot of talks about TFR being an instrument that would massively block out decentralized finance applications. So what it ended up being in there is only transfers where a crypto asset service provider, in the meaning of MiCA, is involved. What's not in there is P2P transfers, so transfers between so-called unhosted wallets. I don't like the term unhosted wallets because it's not unhosted, but I would say self-custodial wallets or self-hosted wallets makes more sense. The requirements regarding transfers now, when it comes down to the travel rule that implements the TFR, is we can divide through two cases. We have transactions between crypto asset service providers amongst each others, like for example Bitpanda and Binance, or Bitpanda and Kraken, or Kraken and Bitpanda, and between CASPs, crypto asset service providers, and unhosted wallets. Unhosted wallets we can further divide into two different cases, namely a user's own unhosted wallet. So I'm a user of Bitpanda, and I have my own unhosted wallet, my ledger, my cold storage, and I do transfers to that ledger. That's the first case. Second scenario is the transfer to a third-party unhosted wallet, which means I'm transferring my funds to someone else in, for example, DeFi sector. So let me start by transactions between CASPs. The TFR applies to all transactions between CASPs, regardless of a threshold. This contrary to the requirements that were originally set up within the FATF recommendations, where a certain threshold of €1,000/$1,000 was foreseen. So what does that mean? That means that now every single transaction concluded between crypto asset service providers has to involve the transaction also, the transfer of certain information, which is written down in TFR, namely name, the account number of a crypto of the wallet, like the wallet address, etc. So the crypto asset service providers, of course, do their KYC and then send all the information they get through the KYC to the other crypto asset service provider. There's a lot of questions concerning that which are still not really solved, especially in the context of GDPR compliance, etc. When it comes to the crypto asset service provider collect and storing the information, the crypto asset service provider is not obliged to verify this information. They just have to receive it. So basically, if I'm Bitpanda and I'm receiving information from Binance, I don't have to verify the information that I received from Binance. Makes sense, of course. What we also see is that, of course, the TFR states that the information should be transmitted in a secure and GDPR compliant way, but there's no precise modalities that are already set out within TFR, but are part of what will be elaborated in further guidelines. So we will see what happens in this regard. Between now to the transfers between CASP and unhosted wallets of its own user. So what happens here is the CASP, if this is actually where a threshold was implemented. So it's a threshold of 1,000 euros. There were discussions going on that this threshold of 1,000 euros would be accumulated, an accumulation of transfers that are conducted within 30 days. Luckily, that dropped out. So right now, if a transfer is concluded between a crypto asset service provider and the unhosted wallet of the user of the crypto asset service provider, and its fiat value is more than 1,000 euros, then the crypto asset service provider is obliged to do a proof of ownership of this unhosted wallet. So he would ask his user, is this your wallet? And the user has to report to the crypto asset service provider, yes, it is. Also, again, there is no examples given of how the crypto asset service provider should do that. But it's right now, it just states in the technical part of the EP, it just states that there should be a Satoshi test or AOOB. Then the last case is the transfer between crypto asset service providers and third-party unhosted wallets. And this is where the negotiations got interesting, namely because most people were scared that through too strict regime here, there would be a divide between CeFi and DeFi. Because if like it was in the discussions that crypto asset service providers would be obliged to verify information received on the owner of unhosted third-party wallets, which is not possible. It is possible, but not really. So what's foreseen, like the conclusion was that now there should be a risk-based approach. What does risk-based approach mean? In legal terms, it's like a best effort clause, which basically means nothing. So it means like, okay, it's up to the crypto asset service provider to decide on an individual case what they're gonna do. But it's nothing really written in stone, and there will always be a room for interpretation. So what are they obliged to do? Martin will know that quite in detail, but it's risk mitigating measures. Also here, there's no concrete examples given. It's up for guidelines that will be also released within 18 months after the TFR enters into force. And such risk mitigating measures, for example, include KYT, so transaction monitoring, on-chain analysis, the identification of people involved into such transactions, and so on and so forth. So, yep, wrong. There's like this is from the negotiations on how this compromise that we now have in regards to these three transaction types actually came along. There was, for example, the council had a mandate. The council had its own opinion. Then the EP mandate. Then they also compared this to individual country solutions, and this is how, in the end, ultimately they came to their compromise. Interesting, but I don't want to go into much detail here. Yeah, what about the way ahead? So we have been talking about MiCA, we have been talking about TFR. Question is, when will it actually be in force? So right now, everyone likes asking, where can we see a draft of MiCA, where can we see a draft of TFR? In fact, there is no such thing as a final draft right now, because there's still technical trialogues going on during July and August. And the truth is that in August, no one in Brussels is working. So we shouldn't expect any final drafts until September, October. Once these drafts are here, they are given to the people that actually draft the laws, so that it's a proper law. Of course, first there will be an English version, then it has to get translated into every single language of all European member states. This will take some while as well. And then in TFR and in MiCA, it's foreseen that after its final adoption, 18 months after its final adoption, it will enter into force. So the earliest that we expect MiCA and TFR to enter into force is end of 2024, start of 2025. Yeah, I just also, what I just wanted to add, maybe right in the end, because it just says, what about AMLR? AMLR is the AML regulation. Right now there's political discussions going on again, and there are new proposals by the Green and the Socialist Party to include all the things that were cut out of TFR again in the AMLR. So they want to introduce the regulations on unhosted wallets, on thresholds, again through the backdoor within the AMLR. So there will be a lot of discussions going on again. But I think ultimately we kind of got over that stage where we say, okay, we have to be scared that unhosted wallets get banned. I don't think that this is an issue anymore because there's been a lot of awareness raising within the European Parliament as well and within the decision-making process. So I think ultimately that TFR is quite a good agreement, like MiCA as well. It's not perfect, but it's a start. And yeah, this is where I maybe hand over to Martin for some comments. Thank you very much.
Yeah, thank you. Also, hi from my side. My name is Martin. I am an attorney with EY Law. And as Georg already mentioned, I'm heavily into with smart contracts also, and started there with from the beginning. Also with my legal career and whether they could be civil law contracts, etc. And that is actually also what brought me in the blockchain space itself, and also here on this panel today, because the European Commission actually looks at MiCA and crypto assets from a bigger picture, as has already been outlined today. So there will not only be regulations or guidelines on how to deal with crypto assets as such, but also on how to deal with smart contracts, especially in a consumer protection setting. And this is also where I am currently involved in some working groups, for example, with the European Law Institute, because therefore we in this working group we're drafting guidelines on how to actually deal with smart contracts in especially consumer settings or also in B2B settings. So there is some regulation that still is going to come, and also some guidelines from the Commission. This is also where we have been touching upon MiCA in discussions with the European Commission, because of course they want to have some kind of a holistic approach. You want to take a holistic approach and have one set of rules that actually really helps in more than just one way. Maybe that just for some background information. And with regard to MiCA and TFR, I think we have already heard a lot of things today, a lot of interesting talks from Oliver, Max, and Martin. So I think there's not too much to add. Maybe if just a few minor remarks from my side. With regard to the TFR and the thresholds that you already mentioned, I think it is very interesting to just, and that's also what we have seen in practice already, that a lot of crypto asset service providers try to some kind of deal with the upcoming travel rule, because they actually expected some kind of regulation to be coming. So a lot of crypto asset service providers are already looking into tools and how they could be compliant with those tools. And what we have seen here in practice is that a lot of the tools that are already on the market do not really address the topic, or always need a threshold, a certain threshold that could be set quite low, but they need a threshold to actually be able to work. So that the Commission now, or that the proposal now does not foresee any threshold, could actually be very bad for these existing tools, and they would have to be some kind of rebuild. So that is something that we have seen in practice. It could be some kind of a hiccup here. Yeah, maybe the other thing that you, Oliver, already touched upon is NFTs. I think that is one of those questions that has already been heavily debated over the last few weeks, or especially last few days, whether they fall within the scope of MiCA and also TFR then. yeah, maybe we can just open the panel discussion here at this point for whether they should fall within the scope of TFR and MiCA. And I think, so what I heard, Max, you have some insights what the current state is, whether they will be addressed in MiCA and yeah, TFR. So maybe you could just switch in.
Yeah, so right now, situation on TFR, on NFTs is still quite unclear. So I can't say too much until the final text is here, of course. But right now the discussion is, so basically NFTs are out of the scope of MiCA. That's what they said. Within the minutes, so within the protocol of the discussions leading up to the conclusion of MiCA, however, there was a mentioning of NFTs that are collectibles or serious should fall under the scope of MiCA. So right now, MiCA states NFTs are generally out, but in the sense of MiCA, NFTs that are serious or collectibles are not NFTs. So this is already what Oliver said at the end of his talk, is that, and I would 100% agree with your point of view, that NFTs that are like, for example, like notes, like money, where you have just different numbers on it, but it's actually the same value, should not fall within this, should not fall within the scope, should fall under the scope of MiCA, because they are collectible, they are serious, right? So, but then again, we have NFTs like, for example, apes, pictures of apes that all have different values. So they should be seen as something non-fungible. And in my opinion, they don't have a degree of fungibility, like it was stated within the discussions. But right now, there's actually people involved into the process that argue that also NFTs like the bored apes, like cypherpunks, etc., should be under the scope of MiCA. So this is something very, very interesting. Also, what we saw is that in regards of crypto assets, of NFTs, other NFTs, which are not collectibles or serious, that national NCAs are now able to reclassify them as crypto assets so that they would again fall under the scope of MiCA. This was something which was in particularly pushed by the German government, which wanted very strict rules on NFTs. They also got out NFT thresholds that were originally foreseen for NFT providers like CASPs. So yeah, maybe Oliver, you want to say something in regards to that?
Yeah, perhaps if I may add one or two thoughts. So the first thought is, I always try to break down things to very basic levels. And if you look at what MiCA tries to address, it's really a question of when people are selling fungible assets that can be used for whatever purpose. We don't need to necessarily go into details what the purpose of the respective asset can be. But the idea is basically you have one central entity or non-central entity in the case of Bitcoin, but then still you have the asset service provider who sells this asset. So in a sense, you still have a central entity. And then you have a bunch of other people who all basically can purchase the same thing. A token which is fungible and and one looks like the other, and that's basically what MiCA aims to address. This one central entity versus a huge number of customers who all purchase the same thing, and that's why it makes sense to have the crypto asset white paper to inform people what the use case and the risks and the like are associated with the crypto asset. That makes sense. On the other hand, if you look at I would now say classical case of NFTs, where it is sold as a piece of art, you don't have this setup. You don't have a central party where hundreds of people try to purchase something of the same value, but it's more or less a new form of art in the traditional sense, if you will. And so it makes sense to exclude it unless you're trying to circumvent the regulation with the NFTs. There was a second point I wanted to make, which I dropped now, but it seems as though you wanted to reply to that. Okay. Help me out, guys. I need a couple of seconds to get my second point.
Yeah, but maybe I would actually agree with you, and that is also what the European the mandate of the European Parliament said, right? In the recitals, they said whenever there is something, whenever NFTs refer to something unique, they should be exempted from MiCA, and they did not say that this could not be, for example, a digital artwork that is unique in a sense. So that is then again just it will be interesting to classify whether this digital artwork is really unique, or, for example, is not unique in that sense, when it's, for example, AI created and therefore not unique in that sense. So that is maybe something to take into mind. Oh, I see you got your point again.
Yeah, sorry, I didn't want to interrupt, but thanks a lot, because now the second point came back to my mind. So the thing is, I think nobody would really draw the conclusion nowadays that you can easily conduct terrorism financing or money laundering using cryptos when you have gatekeepers such as Bitpanda and others who are subject to really tough AML legislation and AML compliance regimes. And I think the risk of money laundering with crypto assets has dropped significantly. On the other hand, if you look at NFTs, which are, I mean, that's for sure, they're not virtual currencies in terms of the anti-money laundering legislation. So AML rules do not apply. And at least in my estimation, the risk for being misused for money laundering or terrorism financing is much greater with NFTs, because the whole art market is prone to that. And exactly here you have somehow a lack of legislative response. And I'm pretty sure that also the proper way to regulate NFTs would be in this regard, namely risk of money laundering, and then perhaps to include it in the next AML directive or regulation. And I think we have a question from the audience.
So you have payment for NFTs, which involves a transfer of value, which is subject to AML laws and regulations.
Well,
you do, because you need people to buy crypto. You need people to basically custodize crypto, either on hosted wallets or on exchange. And then you have the actual transfer, which is traceable. And you said something very interesting about gatekeepers. The gatekeepers are not necessarily the exchanges. The gatekeepers are the Chainalysis, the Elliptic, the blockchain analytics providers, not the exchanges. The exchanges are the interface with the regulators, not the gatekeepers. The gatekeepers are the guys that are able to deconstruct the data to basically follow and trace the wrongdoers.
Okay, I would take this as a comment. When I said gatekeeper, I was referring to the person who somehow safeguards the entry into the traditional financial system. And this is the person that exchanges cryptos for euros, in my view. And in terms of the other comment, yeah, dropped again, sorry, late today.
I actually have to agree with Oliver. The gatekeepers are the ones that really transfer fiat to crypto. And the gatekeepers are those that are obliged by our AML legislation to use third-party providers like Chainalysis, CipherTrace, TIM Labs, and so on and so forth, in order to identify suspicious behavior. And maybe just one more thing to add, and then to your question. There is just, I think it's because interesting. The question is now what's going to happen with NFTs? So NFTs are out of scope generally, but now collectibles and series shall be in. The question is, okay, first of all, there will need to be a definition of what constitutes a collection or a series. That will be the thing that will be discussed within the technical trialogues of MiCA. And then there is 3 ways to go. The first one is to leave NFTs just in the recitals, which would be a pain, because then the whole of MiCA would apply to NFTs. Would be worst case scenario in my opinion. Then the most likely scenario is that NFTs would be collectibles and series would be exempt from section 2 and 5 of MiCA, which means there will be no white paper requirement. There will be not the requirement to have a license as a crypto asset service provider unless you are unless you're the issuer of an NFT and also make it tradable on your platform, like for example OpenSea. Then you would need a license as a crypto asset service provider as well. And the third option, which is the least likely, would be that it's completely cut out of MiCA. I think there's no other option, right? Yeah. So, but what's your question about?
It's now 2. So with regards to basically the transfer value and transfers. So I want to buy an NFT, right? That means I have to buy money somewhere. And we're talking right now only about digital assets, cryptocurrency. And this is the main point of value for all NFT trades. So I am a criminal, and I'm buying an NFT with stolen money. And then the stolen money, before I buy the NFT, I put through a mixer. And then I buy the NFT, and then I sell the NFT, I get more cryptocurrency, and then again I put it through a mixer, etc. Do you think this is a view and only an opinion question, do you believe that the first, like the gatekeeper is you, the exchange where I finally exchange the crypto assets into fiat, or do you think the gatekeeper is basically the tool that allows you or the first exchange to identify what actually happened to the money? So that's the first question. And then with regards to the actual NFT and the value of the NFT, because we've seen NFTs that have been sold at Sotheby's and have been sold at Sotheby's directly for fiat. So there is this whole connection and interchangeability between traditional finance and like actual fiat money and crypto. Where do we draw the line? Where is it actually the value for the NFT or the actually uniqueness of the NFT? Because we've had the one that was sold at Sotheby's, which was a set of 4, if I'm not mistaken.
So referring to the first question, I still see the gatekeeper with the crypto asset service provider. Why? Because using a KYT tool, like Know Your Transaction or like a monitoring provider like Chainalysis & Co. is just one of the risk mitigation measures a crypto asset service provider has to take. Crypto asset service providers still have to take a risk-based approach. So they can rely on the information they get by monitoring, but it's not it's not their decision, like it's still within their decision if they just trust this one provider. And this is why a lot of crypto asset service providers actually use multiple tools in order to do on-chain analysis and to see suspicious behavior. So it's still up to the crypto asset service provider. It's not the monitoring tool, because the monitoring tool just plays one part of the risk-based approach that crypto asset service providers have to are obliged to take. So this is something Martin for sure will be able to say more about.
Well, thank you. I think let's take a step back. I think we can all agree that there is money laundering and terrorist financing risk in NFTs. I think that goes without saying. There are plenty of cases that have demonstrated that. On the gatekeeper issue, I think that's a matter of semantics. At the end of the day, I think that's the concept that is used to refer to financial institutions, because they are pretty much the entry point into the fiat, legal tender world, as opposed to the non-legal tender world of crypto. So hence the gatekeeper thing. But again, that's semantics. But and I agree with the money laundering, terrorist financing risk, yes. But taking a step back, I don't need MiCA for that. I have an AML package for that addresses that in a very specific way, because not only financial institutions are required to perform KYC and due diligence, you have so-called designated non-financial businesses and professions, DNFBPs, a wonderful acronym, that address exactly that, because certain merchants are considered to, or are required, not only merchants, but you have notaries, you have lawyers and such, they have to do KYC as well. And you can do that for NFT platforms. But the problem I think that we see is, do we really need to squeeze NFTs into MiCA? Although we're not really sure to what extent we have done that, and that remains to be seen, and that's very interesting, but I just don't need MiCA for that. So at the end of the day, this is a matter for money laundering legislation, and it should stay there. We can do that, that is feasible, but in terms of interactions with NFTs, I would equate that a little more to commerce, what we see in commerce, as opposed to finance. And I think so there's a reason why we should leave it out as much as possible.
And perhaps to be very precisely, or to be very precise, I would not think that the market for NFTs, so first of all, you can't simply say there's a market for NFTs and this market is prone to money laundering. I really think what's happening is NFTs have swapped or have been pushed into the art market, if you will, and there they are subject to exactly the same risk as you would see with any piece of art. And really what it boils down to is the impossibility to name an objective price for a piece of art. And therefore, the likelihood of using different valuations to launder money, basically.
Maybe just one more quick comment to your comment, to your statement, Martin, because I think we have anti-money laundering rules, as you said, already in place, right? And we have, for example, the Austrian Trade Act, also in their anti-money laundering rules, also for the art sector, etc. So it might just be good to adapt these regulations and also make, for example, make them apply to NFTs as well, because at the current state, they would actually very likely not fall within those strict AML regulations. So it might be another good way to just adapt these existing regulations already that we have, and then again exclude them from MiCA, because yeah, I think that would be actually the better way to go.
And also maybe to add from a practical point of view, looking at the latest Chainalysis reports, NFTs are, money laundering is a thing, but the percentage is so small that it's not really significant. And also what's way bigger problem when it comes down to NFTs is wash trading, and in connection with wash trading, fraud. So basically people pay way too much and lose money.
Yeah, so I mean, again, I'm a compliance professional. Sorry, I put you guys on the spot. There is no, if you look at the statistics, the risks of money laundering, counter-terrorist financing, etc., it's very limited compared to traditional finance and the way it looks now. Martin has touched a very, very interesting point with the NFBPs. The NFBPs are considered to be the highest and riskiest entities currently around the globe for money laundering. And I don't know if you guys follow, but Sotheby's has actually had a few years back a huge scandal with regards to money laundering and art, which is the reason why I touched on the NFT sold at Sotheby's. So my concern as a compliance professional is not AML, CTF risks with regards to NFTs, transfers, blockchain analytics, etc. It's more about integration and what you just touched on, innovation in the sector. The moment when we start to align traditional finance to a regulation regarding crypto assets, MiCA, what we have seen on FATF and the latest guidances, starting with guidance 1516, is where we start to see question marks. And those question marks are exactly what you guys have been discussing tonight. That's a comment, that's not a question.
And to be honest, ultimately, these question marks will remain question marks because the problem is the market is evolving at such fast pace that often there is no answer to a question. And at some point, it's not even a question anymore. If you look, for example, at mixers that were used 5 years ago, they're now all encrypted. So you can actually go back and see, okay, where did the money flow back at that time? Exactly. And this is something we can take, I think, for the whole crypto market. The regulation within the crypto sphere will never be 100% perfect because of the pace it's evolving. But at least we can try. Huh? Also the people and the process of regulation being in place. If you think about it, we have MiCA now, but we will wait 2.5 years until it's actually enforced. So that's crazy.
So I guess those were very nice final words. So crypto isn't perfect because it's human-made. So thanks you all for, Martin, you just want to have some final words?
Oh, no, just for the fun of it. I would say we could have put legislation in a DAO and an enforcement as well, and then we're all good.
No, thanks you all. Thanks especially for that panel, and big applause for all of them. We won't